Negligence means the failure to use reasonable care to prevent harm to oneself or to others. And you can be negligent by what you do or by what you fail to do. There's specific provisions for negligence involving defective products, cars, trucks, locomotives. In essence, our version of the role that oxen played in biblical times. And these rules say that a defendant can be responsible if it designed, manufactured, supplied, installed, inspected, repaired, rented, had anything at all really to do with a particular product, that he was negligent in his conduct with respect to that product, and that somebody was harmed. Very much like what was suggested to us in Exodus 21. Again, the ox gets out, somebody gets killed, there's liability. We have today what we call strict liability in tort. That is liability without negligence. Just as the owner of the ox was strictly liable for what the ox did if he got out, regardless of how he got out or why, we have in California what we call design defect. If a product did not perform as safely as a consumer would expect it to have performed, there's liability. There's another rule that's in the restatement of torts that a lot of other states follow that refer, instead of just design defect, to the concept of unreasonable danger. Anyone who sells a product or is responsible for a product that is unreasonably dangerous means that they're selling a product that is defective and they are liable for the harm it causes, even though they've exercised all possible care to prevent that from occurring. Again, we go back to Deuteronomy and the house construction issue. As I said before, this is a form of liability, not just for negligence, although obviously that would apply, but it's simply a result of building a house without the appropriate wall as required. In a sense, this is the first building code. This is an instance of strict liability. This is a law, and even today we have rules of what we call negligence per se. Negligence just because it is. If there is a law that requires that you do something, whether it's to stop at a red light, whether it's to put handrails on a staircase, whatever it might be, if you violate the law and that violation was a substantial factor in causing an injury, and there's nothing else in the law that excuses you from having been required to comply with the law, then you are responsible. Up to now, I've been talking about what we call civil damages for compensation, the responsibility to make good for the damage that you cause, whether it's the house that collapses and destroys goods that Hammurabi wrote about, whether it's the compensation for a death from the ox that gets out as imposed by the courts. We still follow those rules. It's a civil issue. You hurt somebody, you got to pay for what you did. Our modern civil justice law, our tort law, in fact has its foundation in the Bible and reflects some evolution of belief, some increase of knowledge, maybe some increased sophistication. But when anybody tells you that there's something wrong with our civil justice system, I think it's reasonable to say, hey, it's just from the Bible. It's the way civilization has been in the Western world for 3,000 years. There's nothing wrong with it. People ought to be held responsible for what they do and pay for the damage they cause. Thank you.